All right, guys. So we're in the middle of talking about legality, right? And we've talked about a certain type of legality, and that is contracts which are contrary to statute. And what we saw is that certain prohibitive statutes will cause a contract that is made contrary to that statute to be void, right? And the top example of that is the situation where the contract is to commit a crime or to commit a tort action against someone. Those contracts are void and they can't be enforced, right? And we also talked about gradations on that. Qualifications on that, right? Situations where the court may substitute a legal term for one that is illegal, as in the case of usury, or licensing statutes and gambling and what have you, right? Now we're going to be looking at another type of legality complication, and that is when a contract is contrary to the dictates of public policy. So what is public policy? This is a contract which may have a legality issue due to the fact that generally the courts recognize a difficulty that this type of contract may create for society, right, or for commerce, right? So the first category, let's talk about contracts that are in restraint of trade, right? So this country strongly favors trade, right? And activity, economic activity. If we are trying to make an arrangement, an agreement that is anti-competitive, right, that frustrates competition, and again, we're talking about contracts here that would be viewed as against public policy. The typically such contracts will also violate the antitrust laws of the United States. So when we talk about anti-competitive contracts, right? For example, a contract to fix prices, right, between two competitors would be an anti-competitive contract. That contract is against public policy. It is unenforceable. All right. But certain types of contracts that could be classified as anti-competitive might be a little bit more complicated than that. And I'll spend a minute just to kind of go over those, right? One type of contract that this might come up with is a covenant not to compete, right? So a covenant not to compete generally arises in the sale of an ongoing business or in the context of a contract for services. So let's take the first case, right? Suppose that you're buying a business, right? You're buying a business from a seller who is already engaged in that business, right? And so you include a covenant not to a covenant not to compete. This is also known as a restrictive covenant. It can be created when a merchant who sells a store, for example, agrees not to open a new store within a certain geographic range that sells the same product, right? Why would you want this type of agreement? Because if you're going to buy, say, an ice cream shop, for example, and I buy the ice, you buy the ice cream shop from the merchant, and the merchant transfers the business and then ends up opening up another shop within a mile or within, across the street, right? What is the real value of the contract that you entered into to transfer that business, right? Let's say it was across the street. If my ice cream shop that I purchased and the merchant's ice cream shop, new ice cream shop that he opened after he sold, right, are within close proximity to each other, then they are going to cannibalize each other, just as any other competitor within close range might do, right? No entrepreneur is going to want that result. So a covenant not to compete is generally going to be upheld as reasonable, right? The The exception is when the geographic range might be too expansive, right? It needs to be reasonable, and it needs to be a part of the sale of an ongoing business. So reasonableness is, again, that's the scale that we use to weigh whether something makes sense in the context, right? So if I bought the ice cream shop and the restrictive covenant prevents him from opening another ice cream shop within a mile, that's one thing, right? But suppose that I bought the ice cream shop and I want to restrict my merchant from whom I'm buying that ice cream shop from competing in the ice cream scooping business within the United States. And my ice cream shop is just a little ice cream shop located in Annapolis. Then the court is not going to let me exclude him from the ice cream shop business everywhere, right? Because that's not reasonable. What purpose does it serve? It doesn't actually make my business any more protected, right? So it does have to be reasonable, but within that context, a covenant not to compete can be enforceable. Now we move to the area of employees. Restrictive covenants respecting employees are trickier, right? They must protect a legitimate business interest of the employer. And this generally means that the restrictive covenant is more likely to apply to those who are subject to, well, they have to be subject to employment contracts, as opposed to being at-will employees. It would not be common to see an at-will employee with a restrictive covenant regarding his employment. It could happen, but they would have to pay for it separately. It will generally apply to upper level management or key persons within the organization, right? And this reasonableness that we referred to when we're talking about the sale of a business, it applies here as well. And the geographic region and the time period have to be reasonable, right? So if the geographic region exceeds what the court finds is reasonable, or if the time period exceeds a reasonable time period, then a court is likely to dismiss the provision and allow the former employee to compete. And it's important to note that covenants not to compete, reasonableness, unreasonableness, even whether or not the provision will be enforced varies wildly from state to state. As of the writing of this book, California won't enforce any of them whatsoever. So it's just not a thing that they do. Other states, such as Texas, for example, they won't enforce it unless the employee has received some benefit in exchange for signing the non-compete. For example, it can't just be because you're an employee, right? Unless the non-compete was a part of the conditions of your being employed, right? So they've got to get something else. You can attach it to a bonus or something else. So there can be significant enforcement problems. You need to be aware of which jurisdiction you're in order to actually have a covenant not to compete. Some jurisdictions will, as with usury, right? If you exceed the usury amount in your contract for interest, right, they'll in many cases lower that amount and just place the right amount in. So if the max is 18% and you try to charge 25%, instead of doing away with the interest entirely, they will basically lower it to 18%. The reformation of covenants not to compete is a little bit trickier because it involves judgments that can't be like the usury number. If it's 18%, right, you can't exceed 18%. We know that number is always going to be the same, right? But every covenant not to compete is going to be wildly different, and the benchmark is not a thing like the percentage that's a maximum, right? It's something that's got to be looked at in light of whether there's a legitimate business interest being protected, right? And what is reasonable in light of the circumstances. But it is possible for a court to implicitly become a party to the contract by basically imposing its own terms, and this is called contract reformation. So if the geographic range is too broad, they'll bring it in and make it smaller. If the time period of, say, 12 years, right? And they say, well, I think only 8 years or 7 years is appropriate. I mean, those are all wildly, depending on the situation, long periods of time. But they have leeway in some jurisdictions to be able to plug in their own terms, and they don't really like to do that. So we like to avoid that. None of the parties, number one, if a court reforms your contract, it's not what either party wanted, right? So the best thing to do is to understand what would be required within your jurisdiction in order to be able to maintain that provision. So I'm going to talk about a case called Brown and Brown Incorporated versus Johnson. And in this case, Ms. Johnson became an actuary for Brown and Brown, which is a company that provides a suite of insurance services, and she was an actuary for this company. She had a covenant not to compete that specified that if any of its provisions were declared unenforceable, they should be modified and then enforced to the maximum extent possible. She was asked to sign a non-disclosure covenant, which prohibited her from soliciting or servicing any of the Brown's clients for 2 years after the termination of her employment. Right. Within about 5 years, she terminated her employment. She moved to another company, Lawley Benefits Group. Brown filed a suit in New York State against Johnson, seeking to enforce the non-solicitation covenant because Lawley had customers that Johnson, that basically they shared customers with Johnson, right? So Johnson filed a motion to dismiss Brown's complaint so that she can continue her work. The court notes that a non-solicitation covenant, and again, the court ruled, I should note that the court ruled in favor of her former employer, right? And then she appeals, right? So the trial court says that she can't compete, meaning she can't solicit any of those customers, right, who were also shared by Brown. And this is pursuant to a provision, right, which prohibited her from soliciting or servicing, working for, any of Brown's clients for 2 years, right? A non-solicitation covenant, the appeals court says, is overbroad and unenforceable if it seeks to bar the employee from soliciting or providing services to clients with whom the employee never acquired a relationship through his or her employment. So what are they saying here? You can't keep her from working on clients that she didn't have a relationship with before, right? Because that is more than it covers. It's overbroad in that it covers more than your legitimate business interest, right? Because what's the purpose of a non-solicitation agreement? You don't want her pinching people that she has a relationship with and bringing it to her new employer, right? So the Intermediate Appellate Court reversed the lower court's ruling and granted Johnson's motion to dismiss Brown's action with respect to the non-solicitation covenant, which means she can go on and she can do her work with the new company. They ruled that the covenant was overbroad and that it was not presented to Johnson until her first day of work, and she received no benefit for signing it beyond her continued employment. That's another piece of this that I just recently referred to as in Texas. They won't permit this type of provision unless she receives an other benefit other than simply the grant of her employment. All right. Here is another type of contract which may be illegal because it breaches public policy. And those are contracts which are unconscionable. So unconscionability is a type of defense to contract enforcement. So ordinarily, a court won't look at the fairness of the deal between the parties because we have freedom of contract in order to be able to make whatever deal we want, right? We start with this notion of freedom of contract, which, you could contract for the moon if the moon is available, right? But certain types of provisions may be so unbalanced and so, quote unquote, unfair, inequitable, right? That the courts may intervene in some limited circumstances. But we should start with the premise that most of the time courts won't come to the aid of a party who's made a bad deal just because they were unwise or foolish bargains, right? But if it's a highly oppressive condition, they'll be referred to as unconscionable because they are so unscrupulous or grossly unfair, one-sided, as to be void of conscience, unconscionable, right? So the Uniform Commercial Code, which is the model law that covers this area, incorporates the concept of unconscionability. You'll explore that a little bit more when you get to the Uniform Commercial Code if you do business law too. Specifically, Articles 2 and 2A. Article 2 deals with the sale of goods. Article 2A deals with the lease of goods specifically. So a particular type of contract can be unconscionable under the UCC. There are two types of unconscionability. There's procedural unconscionability and there is substantive unconscionability. This may remind you of the concept of procedural due process and substantive due process. So let's suppose that I get a contract and it's got, some 12-point font, which is the average font that would be comfortably readable by me, some 10-point font, right? And then it's got some 5-point font, which I don't know if you guys know the difference, but for me, that would be practically unreadable, right? It would be readable with great effort, right? Let's suppose that happened. And let's also suppose that, I was given the contract, not given an opportunity to negotiate that contract, and was not given enough time to review a complicated contract, right? Procedural unconscionability involves inconspicuous print or unintelligible language, we call legalese, right? Or other indicia that the one party is trying to get over on the other or confuse the other party, right? So if there's a great disparity in the bargaining power between the parties, it raises the question of whether the consent to that contract is actually voluntary. And so those types of contracts are called adhesion contracts, which are generally standard form contracts that are written exclusively by one party and which offer no opportunity for negotiation. That is procedural unconscionability. And then there is the notion of substantive unconscionability. That brings us to the category of substantive unconscionability. Substantive unconscionability, like substantive due process, has a fairly tight meaning, right? Meaning that there are only certain situations where it's going to come up. It has to be extremely weighted to one party over the other, right? And we're talking about extremely, right? Cell phone contracts, right, that have overly harsh punishments or provisions are often, or have been, if you look in the case law, have been set aside as unconscionable. But here's another example. Suppose that, let's say that I'm the big business and you're the customer, or we're two people in a transaction of some sort. I have unfettered access to the courts, but if you have a problem with me, you're forced to arbitrate. That would be unconscionable, right? It's so lopsided that even if you agreed to it, why would they enforce it? It is, it's a benefit for me to be able to sue you wherever I want or arbitrate. And it takes away your right to sue, which otherwise you would have if you hadn't given it up. So even if you negotiate that and it goes, or even if that is a provision in that contract, it may not, in fact, end up being enforceable by the party with the stronger benefit. And a closely related concept to this is the notion of exculpatory clauses, right? An exculpatory clause releases one party from liability in the event of some type of injury. It could be a monetary or a physical injury. And it is without regard, the exculpation is without regard to whether the party who is being exculpated is at fault or not, right? Now, sometimes the courts will endorse these clauses and sometimes they will not. They will refuse to endorse them and will treat them as if they are also unconscionable, right? They may view them with disfavor, but again, they can sometimes be useful. But Speedway Super America hired Siebert Irwin to work in one of its convenience stores. The company required Irwin, who had an 8th grade education, to sign a contract stating that he was not an employee and had no right to workers' compensation. The contract also included a clause under which Irwin promised not to hold Speedway liable for anything that happened to him while working for the company. Irwin was in bad straits to sign this agreement. But when Irwin was later injured on the job and sued Speedway for damages, the court held that the exculpatory clause was garbage, i.e. invalid, because it was against public policy. It was basically a flat-out case of employee abuse, right? Because, they don't even want to admit that he's an employee. They want to call him something else, as if he is an independent contractor, which he clearly is not in circumstances like that. So when will courts actually respect or endorse these exculpatory clauses? They must be reasonable, they must not violate public policy, and they shouldn't protect parties from intentional wrongdoing against someone who is being injured, all right? We can start there, right? That may still raise a question in the court's mind about exculpation, but if you start there, you have a higher likelihood of having the provision actually be sustained in court. And it must be obtained, this exculpation has to be obtained by clear language, non-ambiguous language, and they have to be in relatively equal bargaining positions. This doesn't mean that they're the same size or of the same wealth, but it means that the party against whom the exculpation is sought to be enforced, right, the injured party, right, had as much opportunity to negotiate and ability to negotiate, right, as the party for whose benefit the exculpation is being obtained. Many businesses which engage in leisure and recreation may use this type of exculpatory clause to limit the application of liability for injuries to their patrons. Because these services are non-essential, right? It's not food, shelter, clothing. It's more likely that these types of businesses will be allowed to use exculpatory clauses. Why? Because I can either go to the health club or the bowling alley or do this ropes course or not, right? It's not essential to my survival. I don't have to have it. And by virtue of that fact alone, I've got some negotiating power. I don't like that provision. I can go somewhere else or simply skip it altogether. So generally, the effect of a contract which is illegal is that it is void. It has no effect. So this means that the contract is executory and remains to be executed, then it cannot be enforced. And if the contract is executed, then you can't get damages. The court will generally hold both parties as equally at fault because just ignorance of the law is no excuse. You've heard that cliche before. But they're basically going to hold both parties to be equally responsible because both parties agreed to the contract. In some cases, though, you can have some types of ignorance, for example, a justifiable ignorance of the facts, which can produce a different result, particularly where one of the parties doesn't know of the illegality of this type of contract. Maybe it's because they're in a new jurisdiction or what have you, and they're relatively innocent in relation to the other party. They may be able to recover any benefits that are conferred in a partially executed contract. So they won't enforce the contract, but they'll allow the parties to return to their original positions, right? So, and a court can sometimes permit an innocent party who has fully performed under a contract to enforce the contract against a guilty party who does not. So a trucking company contracts with Gillespie to carry crates filled with goods to a specific destination for a normal fee of $5,000. The trucker delivers the crates and later finds out that they contained illegal goods. This was a justifiable ignorance of the fact. He wouldn't have known that the contract was, in fact, illegal. The shipment, use, and sale of illegal goods would be a prohibition that would make that contract void. In this case, Gillespie the trucker is not aware of any factors that would make it illegal in this jurisdiction, so he's going to be able to recover the entire $5,000. So another category that we need to explore, the effect of illegality. If a law is aimed at a protected class of people, say employees, right? An employee who is in this protected class may in fact violate the law, right, by doing certain things for their employer. For example, a law which requires that pilots and flight attendants have a certain amount of rest and not work more than a certain number of hours within a certain period, right, means that the employee cannot be required to do so beyond the statutory limit. But let's say the employee, for whatever reason, works the extra hours, right, against the law. It is not the employee who's going to be punished. The employee is entitled to recompense for the amount of hours that they work, even though that contract is illegal. But they are the party that's being protected by the law. They are not to be punished by it. So, suppose that at a party, Marty and Andy decide to wager illegally on the outcome of a boxing match. Each deposits $1,000 with a stakeholder who agrees to pay the winner of the bet. At this point, each party has performed part of that agreement. It's executory, right? Before the payment occurs, either party is entitled to withdraw from that agreement by giving notice to the stakeholder of his or her withdrawal. I know it sounds a bit odd that someone would welch on a bet. I'm not even sure if that's like a slur or not. Maybe I shouldn't say that. Maybe it's the pullback on a bet, right? But if the illegal part of the bargain has not yet been performed, then the party who is rendering performance, in that case, can pull back and cancel the deal. And lastly, let's talk about fraud, duress, and undue influence. All right. These are also self-styled or styled as defenses to contract enforcement, and they come up in the context of illegality, as with unconscionability and some of the other ideas that we've talked about in this section. All right. So fraud, duress, and undue influence. Fraud you'll recognize as connected to the tort of misrepresentation, of intentional fraudulent misrepresentation, right? So if a contract is obtained by fraud, right, it may simply be set aside as unenforceable. Duress is an undue stress caused by one contracting party on the other contracting party. Think of duress as holding a proverbial, if not actual, gun to the head of the counterparty to the contract, right? And then there is undue influence. If one party has extreme authority or power over another person, for example, I'm your guardian and you're 87 years old, and I pressure you to put me as a beneficiary in your will, right? And it's not under your own sort of, sound, and I'm caring for you every day. You better put me in that will, right? That can be undue influence. That could be set aside. All right. Fraud, duress, and undue influence. So those are the types of legality or opportunities to attack the legality of a contract. And lastly, I'll say a word about severable contracts or divisible contracts, right? A contract which is severable or divisible has distinct parts that can be performed separately, right? And there may be different consideration for each part, right? If the contract, however, is indivisible, complete performance by each party is essential, even if the contract contains a number of seemingly separate provisions, all right? So if the contract is divisible into legal and illegal portions, right, a court might enforce the legal portion and not the illegal portion if the illegal portion doesn't impact the essence of the bargain, right? So this is consistent with basic public policy, where the courts just kind of, if you remember the rules of contract construction, the court will will attempt to give a legal meaning that can be effectuated in a contract. If it can be done without sort of defying the actual intention of the parties, then the court will do so. So as an example, Cole signs an employment contract that is valid but includes an overly broad and an illegal covenant not to compete. We talked about this just briefly before. In that situation, the court might find that the employment contract is enforceable, and they may reform or change the unreasonably broad covenant by converting its terms, which were unreasonable, into terms which it regards as reasonable, right? Or they could just declare the covenant illegal and drop it from the employment contract entirely, right? So we have gone through the classification of contracts, right, and the different types of contracts. We've gone through agreement, which is offer and acceptance. We've gone through consideration, and then just recently we've gone through capacity and legality. This brings us to the edge of what I'm able to do within the time that we have allotted for this semester. And this is the basics of contract formation. And so, first of all, I would like to say thank you for holding out for this long. This will be the last video in the series. You should answer the prompt below. And the next thing that will happen is that you'll begin to work on your final exam project, which will be posted shortly. I thank you for your attentiveness this semester, and I wish you all a prosperous and happy summer. You can still contact me via email with questions and via text with questions. I'm happy to do so. We can also have a Zoom meeting to clarify, and I will let you know when we will have a review session, which will be prior to the due date of the 22nd of November. That is the absolute last date, because I have to get grades in immediately after that, within 48 hours. There are also a number of other options. If you feel that you need to take an incomplete, I'll grant those liberally. And withdrawals also are granted liberally due to the circumstances of the semester. Thank you guys so much. It has been a great pleasure being your teacher, and I look forward to seeing some of you in business law too. All right, take care. Bye-bye.